SHRM Linkage is proud to be a partner of All Things Work. For more than 25 years, organizations and their leaders have attended the SHRM Linkage Institute for data-driven leadership development with a focus on advancing women leaders. This Women's History Month, commit to meeting the unique needs of women in the workplace. Register yourself or your team for the SHRM Linkage Institute at shrm.co/institute.
Welcome to All Things Work. I'm your host, Ann Spiracco. The White House's recent Diversity, Equity, and Inclusion, or DE&I executive orders have prompted renewed scrutiny around workplaces, equal employment opportunity efforts, and anti-discrimination laws. It's also swirling around a lot of questions for many professionals out there. So today we're digging into one of the most important anti-discrimination laws we have in the U.S., Title VII, to examine what organizations should know, review, and potentially adjust given the recent executive order's broader implications. So joining us today is Sarah Goodman, counsel for law firm Offit Kurman, to talk about this very, very important and relevant topic. Welcome to All Things Work, Sarah.
Thanks so much. It's a pleasure to be here.
We're happy to have you, especially with such a big topic. Your guidance will really be helpful for our audience. So let's start off with, can you give us a little bit of your background and what led you to focus on employment law and labor relations?
Absolutely. So it was a happy circumstance. I am the child of a plaintiff's side labor attorney in Philadelphia. He and my brother worked together, so shout out to Rains, Lawn, and Haymeyer in Philadelphia. But I decided to be the black sheep and go to the dark side. And after law school, practiced at a small firm in Philadelphia where I really learned how to be a lawyer. And based on sheer coincidence, someone went out on maternity leave, and they primarily did all the firm's labor and employment work. And I inherited that caseload, and here we are today.
It's in your blood. That's great to hear. So let's kick things off, reminding our audience the details surrounding Title VII. Can you walk us through what Title VII does and does not protect against, and how it has evolved over time, really?
Absolutely. So Title VII is a statute that has been enacted since 1964, and it is the cornerstone to how we understand civil rights law and, frankly, employment law in this country. What it does is it protects various protected categories from discrimination, harassment, retaliation. And what that means really is you cannot discriminate against an individual or a body of individuals based on the color of their skin, their gender, their religion, their national origin. It's also been broadened to protect categories such as sexual identity and gender identity, and continues to change and evolve. But at its core, it is fundamentally in place to ensure that we as Americans are not discriminating, targeting, singling out one body of individuals or an individual because of how they look or how they dress or how they choose to practice their faith.
Right. And it's been around for a long time, signed by President Lyndon B. Johnson, as you mentioned. And so you talked about just kind of, what it protects, what it does not protect against. But really when it comes to how it generally plays out in the workplace, as far as what it legally prohibits employees, managers, really anyone from saying or doing, can you provide maybe a little bit more context to that? I know we touched on it a little bit.
Yeah, absolutely. So we're two women sitting here today. Let's say you and I decided we wanted to become firefighters or join a police force.
Right.
And in order to do so, we had to submit an application, just as anyone would. But we also had to take a physical fitness test. And just by virtue of our sizes, what we weigh, how tall we are, we were unable to pass this physical fitness test. It had nothing to do with the fact that we were women, but just genetically how we are made up. This test was really insurmountable and impossible for us to pass. So that's one way you see Title VII play out, right? So it's a safety test in theory that is put in place by an organization, in my example, a fire station. But the fire station doesn't want to discriminate, doesn't want to block women. But unfortunately, the fire station has to take a hard look at what their test is requiring, because you and I just we can't do it. Give it our best try, and there's no way. Similarly, it prevents employers from using a quota system, for instance, in order to distinguish who makes it past the first round in hiring, or who is promoted. And also just across the board prohibits specific treatment, and that could be positive treatment, it could be negative treatment towards, again, an individual or a body of individuals because of how they look or what they observe or how they, choose to dress.
So now that we really covered what Title VII covers, why would you say it's critical now more than ever for everyone in the workplace to really understand it, but not just understand it, but to follow it?
Sure. So, it's very interesting. We're in the second round of the Trump administration, and many who follow closely would say that, during Trump's first administration, DEI was high on his list. And now that we're in the second round of a Trump presidency, I think we've already seen that it's an increased focus. So why does that matter in relation to what you and I are talking about today? Well, it matters because nothing is changing about the law. Title VII is a cornerstone, in my opinion, of American jurisprudence. That's not changing. That's not going out the window. What is changing is how an administration chooses to enforce the law and what they're choosing to prioritize. So I think businesses take away two things from this. One, you have an administration that has a history of targeting these types of programs. And then two, moving forward that you may have a DEI program or diversity efforts that are going to be under scrutiny just by virtue of the fact that this administration has identified it as a priority. But again, I can't reiterate enough, the law isn't changing. Nothing here is changing. Title VII isn't going anywhere.
That's a great reminder because it can be overwhelming with a lot of the headlines coming out and so many different things changing. And I think our executives here at SHRM, really have done an excellent job in trying to remind people, take a step back from that busy, headlines, everything popping up on your phone, and try to breathe and realize, what is really going into effect, what is not, where should we comply. So it's really trying to think more about the strategy and, what you can and cannot do right now. So I think that's really great reminder, especially to just kind of take that step back, breathe, and remind yourself, what is law, what is the interpretation here, and where the power is. So that's good to know. So how have you been seeing these executive orders and any other legal shifts impacting businesses' discrimination policies and equal opportunity practices? For example, like the Supreme Court's 2023 ruling on affirmative action on higher education.
So that 2023 decision, certainly is instructive, I think, for private employers. But again, it's not really directly on point to what we're talking about today. And just as a quick refresher for those who may not know, Students Against Fair Housing decision was a case brought against Harvard University and UNC. And essentially, the Supreme Court found that using any kind of metric tied to race as part of the admission process was unlawful because it violated the Equal Protection Clause. Different law, not what we're talking about here, but again, possibly instructive. And I think, frankly, that's what the executive orders are as well. They're instructive for private employers. For the most part, they target federal contractors. So certainly something to be mindful of if you do work in that space or if you work with subcontractors who may have an affiliation with a federal contract. But for private employers, the executive orders don't really apply. But
Right.
again, I think the key takeaway here is what can we learn from this? What is the administration doing, and what is the administration targeting as hot button issues? So we know that diversity, equity, and inclusion efforts are a prime focus of this administration. And I think at its core, the administration is essentially saying, we're trying to level the playing field. We don't want anything other than true qualifications and meritocracy to be the decision maker or the law of the land, or what will allow you to either be hired or not hired.
Right. Thank you so much for walking us through that little sidebar of the topic that we're discussing today. So I want to dig into a little bit of recent SHRM data. SHRM conducted a survey in early 2025 of this year, and found among HR professionals who anticipate their organization will be impacted by these executive orders, 65% of them say they feel they're underprepared to address the potential implications. Just going to let that sink in. 65% of them feel unprepared for these implications, potential implications at least. And additionally, SHRM recently held a webinar which included a poll, and that poll found over 60% of the 11,000 people who attended our webinar said they're not very confident in their understanding of the executive orders and how they exactly intersect with Title VII. So clearly there's a gap in understanding here, and there's really a need for preparation. So what do you think organizations should do to help their HR and business leaders feel prepared during this time?
Absolutely. It's remarkable data that SHRM's been able to gather. And it really is. It's quite alarming, right? Because we want, I think businesses across the board want their HR folks to feel prepared and know how to handle things when they come down the pike. So I think your question, is twofold. First and foremost, consult with legal counsel. I feel like that's the most frustrating answer for anyone to hear, particularly from a lawyer, because there are nuances that come into play, and a good lawyer and a true advocate, in my opinion, will help tailor your exact business model to, frankly, your risk tolerance and what may or may not make sense to address, and lay out a plan that you all can work from. Secondarily, I think training is key, and I think that really helps bridge the gap. So I personally do Title VII trainings all the time, and there's typically a different training for your general employee base and your managers. So HR trainings exist too. You could do a very high level training for HR before you then get to the employee base and the manager level training. And that can be really helpful, because then, especially if it's done in person, you have a point person that you can call should something come up, right? HR people are some of the smartest folks I've ever met. They know, right, when the red flags come up. They know if they get an employee complaint and it smells bad or it makes them uncomfortable, it's probably time to bring in someone else to help navigate the situation and guide them to a resolution. And 99% of the time when that happens and a client reaches out, we're able to partner together to align on strategy, whether that's ghostwriting, performance improvement plans, or helping prepare emails. But having that partner is crucial.
I agree. Definitely the partnership is very essential. You need the support. That's why people go free for your expertise, which is why it's so great to have you on our episode today. So one of the ways SHRM is actually helping workplaces prepare for the potential implications of these executive orders is with our BEAM framework. Now, that stands for Belonging Enhanced by Access Through Merit. BEAM, of course. Our framework uses merit as the primary lens, focusing on measurable performance and skills-based assessments to help organizations eliminate biases and ensure their decision to reflect potential, not privilege. So, what role do you see merit playing as businesses navigate employment law in 2025?
I think it's the buzzword of the next 4 years. Or applaud Shroom on the BEAM initiative. But, certainly, if you read news, right, in the morning, I think most people suffice it to say, they'll grab a coffee, look at headlines, and it could be from any news source out there. And oftentimes you see flashy headlines or frankly scary headlines for some. And it's hard to make sense of what it all means. To me, the key takeaways of the Trump administration's efforts as it relates to DEI is really to strike the D and insert meritocracy. So goes back to, I think what I said, probably 5 or 10 minutes ago, but looking at true qualifications, how does someone perform day in and day out? Performance is the driver of all key employment decisions. And I think that's the prime takeaway from this administration and the best benchmark for how you can ensure that there's no bias or preferential treatment in any type of employment decision within your organization.
I think we touched on this a little bit, but maybe we could expand here. So what are some of the best practices organizations can follow to remain compliant in accordance with the executive orders, Title VII, and other laws focused on ensuring equal opportunity? I know you touched on, obviously touching in base with your legal team, getting that expert help, that partnership. But what are some other best practices?
Yeah, absolutely. I really believe that at its core, any type of inclusion effort should be tied to the business's identity. And what do I mean by that? Diversity, equity, and inclusion is not a term that we just pulled out of a hat, 8 years ago because lawyers thought they needed more business or, people wanted to change the American workplace landscape. It is studied, right? There are McKinsey reports on this. There are HBS reports on this. Most people, if you believe the stats, science-based, factually based, there is value in incorporating a wide variety of beliefs in an organization. So what does that mean? I think any business, regardless of size, needs to take stock of what its priorities are. So what that means ultimately is, do you want to value inclusion and equity efforts? If the answer is yes, then the next question is, what is your risk tolerance? You know what this administration's position is, how much risk are you willing to take on? And that's probably going to involve conversations with key stakeholders and ultimately, a decision made on behalf of the business. And then from there, the business is able to execute a plan that falls in line with A, its core beliefs, and B, can match its risk tolerance. So I think that's step number one and the best thing that any business can do, because if it identifies, who the business is at its core and allows its initiatives or decides not to have an initiative because of that, be the driving force, that answers a lot of your questions, right? It's your key core identity. And from there, it's all about looking at implementation, making sure you're not using quota systems or preferential treatment. You never want to hear, and as a lawyer, you always kind of grimace when someone says, we have an open position and we've taken stock of our workforce. We really don't have enough Black women. So this new hire needs to be a Black woman. That kind of selection, that's not true DEI. And that's where you get yourself in trouble. So it's about identifying what your core belief is as a business, putting it in place in a legal way that makes sense and aligns with your business's ultimate end goal and risk tolerance. And then from there, educating, your key workforce. And what I mean by key is your HR, your manager level folks, so they know what to look for, what our core beliefs as a business is. And when I say our, I mean the audience's business. And you go from there. And it's much easier to execute once you have that identified and a plan set in place.
So would love to bring in a little bit more data from outside of SHRM. A February 26th report from employment law firm Littler showed over 50% of C-suite leaders say they are worried about the risk of diversity-related lawsuits and government enforcement. It's kind of a realistic number here, over 50%. And so my question regarding this is, what risks, both legal and operational, do organizations face if they fail to remain compliant? We talked about the preparation, but I'd love to dig into a little bit about, what they should do and what are the risks here if they fail to be compliant.
Great question. So, first and foremost, I think when you operate a business, just the fact that you're opening your door and saying, come in, I have services or products to offer you, you open yourself up to some legal risk, and you should have some kind of legal budget. What you're not asking about, I don't think, is the rogue employee who you've done everything right by, and they still hit you with an EEOC charge the moment they're terminated or suffer some other adverse employment action. Hard to mitigate against rogue claims or rogue claimants. But there's certainly things that you can do to help, right? And it goes back to sort of the key fundamentals of employment law 101, handbooks, policies and procedures, making sure your managers are well-versed in policies and procedures and know how to implement fairly those procedures across the board. I think what is most interesting when we talk about DEI programs is that we don't yet know the real answer to your question. We know that this administration has targeted these programs as something that they are keeping a very close eye on. I think President Trump, during his presidential address, went so far as to say he has eliminated DEI in the federal workforce. And we know Pam Bondi has been empowered to create a task force and go after private employers, theoretically, who have DEI programs that conflict with the Trump administration's agenda. What we don't know is what those lawsuits will look like, how companies will be targeted, what lead up to penalties being issued there will be. So that's a wait and see, in my opinion. And that's not always the easiest answer, but I think it is safe to say that if you are risk adverse, you should be very, very careful and take a very close look at your DEI policy if one exists. And if you have more risk tolerance, and this is a program that you stand by and your business stands by and is something that you've identified as core to your business's beliefs, then we can talk about ways that we can ensure your policy is defendable under Title VII and ensures merit-based equitable outcomes, right? So that means, again, no quota systems, no identifying certain individuals based on how they look and targeting them, and going from there. I think that is the true fundamental way of identifying how you approach these things.
That's understandable. Yeah, thank you for that. Really, really practical advice throughout this whole episode. It's really been helpful, and I hope our audience really takes away a lot from this. I would love to kind of zoom out a bit for our final question because you've given us such great advice. At SHRM here, we are very passionate about creating inclusive and diverse or IND, workplaces. Johnny always says, you can have everybody at the table, but if they don't feel included, then what's the point, right? So I think that's, we'd love to foster inclusive workplaces. So I'd like to leave our audience just with one last piece of advice from you, if you can, about what you would like to give to businesses to ensure both compliance and a commitment to fostering inclusive workplaces, just to make sure that they're doing that. What are your final thoughts that you would like to leave with our audience for businesses?
Absolutely. I really think it comes down to identifying a business's core values and figuring out a way to carry out those core values across an organization and making sure you are educating your top level managerial workforce about those core values And then figuring it out from there, right? Every business will have a different level of risk tolerance. Partner with a good employment lawyer that you trust. I can't plug that enough. And you will be fine, right? There is a way through this. And I think there's a way through this where everyone benefits. And, it's a lesson, if anything, to just pay closer attention to how policies across the board influence your workforce. And the reality is, if your workforce is happy, you have less legal problems, right? So core beliefs, make sure people are aware of them, and deal with what comes.
It's really going to help push forward those healthy workplace cultures, and that goes a long way. So thank you so much, Sarah, for sharing your experiences and in your really deep insights and in your really practical advice here on this episode. We appreciate what you had to share today.
Absolutely. Thank you so much for having me.
Of course. All right, that's going to do it for this week's episode of All Things Work. We have new content out each week with a newsletter and the latest research on these big and super important topics. Just head to shrm.org/allthingswork for more and follow us on social media. Like, comment, share. We want to hear from you. That's it for this week. We'll catch you next time.
This episode is supported by SHRM Linkage. Learn more about the SHRM Linkage Institute's data-driven approach to advancing women leaders at shrm.co/institute.
SHRM.